Regional Land Registration.
Registration of lands can be original or subsequent, so let's focus on original registration. It is when an original certificate of title or OCT has been issued to an owner by the Register of Deeds. It is the land that is subject for original registration and public for alienable and disposable lands and abandoned or in dry river. A and D lands are declared as patrimonial property and subject for alienation through prescription. Some necessary to file original registration are approved plan, survey, description, and other monuments of titles. It may be filed directly at the court, for example, is judicial proceedings, by the claimant or through the initiative of the DNR. For example, is cadastral proceedings upon the order of the President of the Philippines.
Who can apply regional registration?
According to Section 14 of PD 1529 states that the following persons may file for registration of title to land whether personally or through duly authorized by their representatives. First, those who have been in open, continuous, exclusive, and notorious possession and occupation of alienable and disposable lands since June 12, 1945 or earlier than that. Second is those who have acquired ownership of private lands by prescription. Next is those who have acquired ownership of private lands are abandoned riverbeds by right accession or accretion. Lastly is those who have acquired ownership of land in any other manner provided by law. And if you are a natural born Filipino citizens and with legal age.
Where to apply or file application of Judicial Regional Land Registration?
The application for land registration shall be filed with the Court of First Instance of the province where the land is located.
What are the basic requirements?
First, the basic requirements is the original plan in tracing cloth duly approved by the Director of Lands, Regional Lands Director, or Regional Technical Director, and two blueprints copies duly certified by the aforementioned officers. Second is the three copies of technical description that conforms with LRC circular number 365, which duly verified and certified by the regional technical director of his or his authorized representatives. Third is the three copies of certificates from the surveyor or geodetic engineer or certificate of non-availability from the regional technical director, and last, 4 copies of the latest tax declaration or assessment certificate from the assessor's officer where the land is located.
If the land to be applied does not have an approved survey, where to
Any
go?
person can obtain an approved survey from the Land Management Bureau or LMB and a copy of the land title from the Land Registration Authority or LRA. Must provide the name of the owner, lot number, and the lot location, then filing out application and paying fee. This is public information that should obtain before moving forward so that it can be sure to buy an unencumbered lot with a clear title from the person who has the legal right to sell it. Also by checking whose name is listed, paying their yearly taxes with the municipal treasurer's office. You can also get information from tax receipt. Tax receipt will show the owner of the property and will also show the name of the person who has actually been getting credit for paying the taxes. If necessary, consult with an attorney. Other else in Department of Environmental and Natural Resources or DENR whether a land is alienable and can acquire to own a lot or not. for protection and conservation of natural resources.
What are the processes of judicial original land registration? There are 7 steps for this process. First is the filing of petition, where you will file the application for land registration in the regional trial court. Next is the notice of hearing, where the court shall, within 5 days from filing of the applications, issues an order setting the date and hour of the initial hearing. Next step is the initial hearing, where the date and place of the initial hearing shall be set not earlier than 45 days. Next is the opposition. If any person claiming an interest, whether named in the notice or not, may appear and file an opposition on or before the date of initial hearing. Next step is the no opposition. If no person appears and answers within the time allowed, the court shall, upon motion of the applicant, no reason to the contrary appearing. And next is the presentation of evidence. And lastly, the decree.
What is a decree? OCT.
A decree is an official order given by a person with power or by a government. Its purpose is to order handed down by a judge that resolves the issues in a court case. Original certificate of title is a piece of a document or a record that acts as proof of ownership of a property. It can come in some forms such as a tax declaration, deed of sale, or a torn certificate of title.
Who prepared the decree? OCT.
According to Section 39 of PD 1529, preparation of decree and certificate of title. After the judgment directing the registration of title to land has become final, the court shall, within 15 days from entry of judgment, issue an order directing the commissioner to issue the corresponding decree of registration and certificate of title. The clerk of the court shall send within 15 days from the entry of judgment certified copies of the judgment and of the order of the court directing the commissioner to issue the corresponding decree of registration and certificate of title, and a certificate stating that the decision has not been amended, reconsidered, nor appealed and has become final. Thereupon the commissioner shall cause to be prepared the decree of registration as well as the original and duplicate of the corresponding original certificate of title. The original certificate of title shall be a true copy of the decree of registration. The decree of registration shall be signed by the commissioner, entered and filed in the Land Registration Commission. The original certificate of title shall also be signed by the commissioner and shall be sent, together with the owner's duplicate certificate, to the register of deeds of the city or province where the property is issued, situated for entry in his registration book.